Good morning. Welcome to EduSet Network. Friend, today we are going to discuss fundamental rights. In fact, we have organized series of lecture on fundamental rights, and in previous lecture we have talked the different articles, and today we will have a discussion on preventive detention and right against exploitation. And for discussion on this very topic, we have introduced the same resource person, Dr. Rakesh Kumar. He teaches law and legal issues, Constitution of India in University School of Law and Legal Studies in Guru Gobind Singh Press University, and his area of specialization is Constitution of India and constitutional law. So I think his knowledge and experience will help us to understand this article related to preventive detention and right against exploitation. So on your behalf, I welcome him for the EduSet lecture on this very topic. Welcome, sir.
Thank you, sir. Good morning, listeners. In my previous lecture on fundamental right, I have covered up to Article 21 of the Constitutions. In today's lectures, I will continue from Article 22 onwards. What I said in under Article 21 is that the state, no person can be deprived of his life and personal liberty except the procedure established by law. It means Article 21 itself mandates the state to deprive the person of his life and personal liberty, provided that deprivation is having the backing of the procedures prescribed by law. So, if any person is sought to be deprived of life and personal liberty, then for that purpose we needs to have the valid law, and that valid law must prescribe the just, fair and reasonable procedures. And Article 22 of the Constitution guarantees or assure the minimum safeguards which has to be followed if any person is sought to be deprived of his life and personal liberty by the state or any of its instrumentalities. If you see the provisions of Article 22 of the Constitution, it deals with the two kind of contingencies. The first contingency pertains to those cases where the person is being arrested under the ordinary law of the land for the commissions of the particular criminal offence. And second aspect of Article 22 deals with the preventive detentions law, where the person is being detained by the police, detained by the state, not for the purpose of not for the purpose that he has already committed an offence, but for the purpose of preventing that persons or intercepting that persons before he go and commit the offence. The basic object behind the safeguard, the minimum safeguard which has been assured by Article 22 is that it is intended to avoid any kind of miscarriage of justice, and it is correct or to check the use of power by the executives in arresting or detaining a person. If you see the provisions of the nature and scope of Article 22 of the Constitution, then the first questions which arise with respect to Article 22 is that who are entitled to claim these rights which is being provided by Article 22 of the Constitution. As far the provision rights under Article 22 of its concerns, this right can be claimed by every person, whether he is a citizen of this country or he is a non-citizen of this country, and even the foreigner can claim these safeguards which is being provided by the Article 22 of the Constitution. But as far the applications of Article 22 is concerns, here it will apply only with respect to the criminal offence or quasi-criminal offence which is committed by the persons or which he intends to commit under the second aspect of Article 22, that is the preventive detention law. Here Article 22 cannot be claimed by the persons who is being detained under the civil matters or who is being detained for the purpose of under the warrant of the court or for the commission of the contempt of court. So Article 22 does not apply to arrest detentions made under the warrant of court, and Article 22 will also not apply if there is no allegations or accusations of any actual or apprehended commissions of the offence. Now I am coming to the first aspect of Article 22. First you see what kind of the safeguards which is being provided to the persons under Article 22 of the Constitution. If you see the clause 1 and clause 2 of Article 22, it guarantees the 4 distinct safeguards to the persons who is required to be arrested under the ordinary law. The first right which the arrested person is having the right to be informed as soon as may be of the ground of arrest or detentions. And second, he has the right to consult and to be defended by legal practitioners of his choice. Third right which has been provided by clause 1 and 2 is that the right to be produced before the nearest magistrate within 24 hours of his arrest, and fourth, he has the right not to be detained in custody beyond 24 hours without the authority of the magistrate. So, now I am coming to the first specific right which is being provided by the clause 1 and 2 of article 22 of the constitution. First, you have the right to inform of the ground of arrest. Now, if you see the clause 1 here, which required that any persons who is arrested should be informed of the ground of arrest. So, now the question is, what is the objective? Why the person who is being arrested by the police must be informed of the ground of arrest? This is because this is the basic imperative requirement, this is the mandatory requirement, and the basic object of this provision is to enable a person arrested to know as to why and for what offence he has been arrested. So, it will afford him the earliest opportunity to remove any mistake or misapprehensions or misunderstanding in the minds of the authority making such arrest. So, the ground for arrest are to be informed to enable the detainee to prepare his defense, and appropriate case they can also move to the court by writ of habeas corpus if they are apprehending that this such arrest was being made by the police, it is without any basis or without any justifications. So, the first thing is that you must be informed as to why you are being arrested. So, why and how you are being arrested, this requirement has to be fulfilled by the executives. This requirement has to be police if the police intended to arrest any persons under ordinary law. So, once the ground is being informed, then just to ensure that this requirement is being validly complied. Here the Supreme Court in Joginder Kumar's state of UP case in year 1994 has laid down the certain guidelines. These guidelines are intended to augment the right which is being provided to any persons under the clause 1 and 2 of article 22 of the constitution. In this case, the court said the person is not liable to arrest merely on suspicions of the complicity of the offence. There must be some reasonable justifications in the opinion of the police officers effecting the arrest, and such arrest was necessary and justified. So, in Joginder Kumar case, mere complicity of the offence is not a ground for the arrest. There must be a sufficient reason, there must be a reasonable justifications before the police wanted to police effect the arrest of the persons. So, once the person being arrested, then the questions will arise to what kind of the right he is having after the arrest which is being made by the police. The first right which is being assured by the judiciary in the Joginder Kumar case is that the arrested persons being held in the custody is entitled, if he so request, to have one friend, relatives or other persons who is likely to take care of his welfare. So, the moment he is being arrested, then he can request to the police officer or he can inform to the police officers that I want that one of my friends or my close relatives must be called here and he must be stand nearby. Nearby does not mean that the relatives or the friends will stand along with the person who is being arrested, but he has to be in the sufficient vicinity. And the second thing that it is not only that he is having right, here the obligation is being also imposed on the police officers, that the police officer is required to inform the arrested persons that you are having this kind of right. You can call any of your friends or relatives who are interested or who can take care of your welfare during the time of the police custody. And the third things which the Supreme Court said in the Joginder Kumar case is that the person who is being informed, it must also be recorded in the police diary as to who is being informed about the arrest of the such persons. And it is not only that the police is required to follow this formality. When the case has been presented before the magistrate, then magistrate is also put under obligations that they have to ensure that these constitutional obligations which is being imposed by clause 1 and 2 is duly complied by the police officers during the detentions or the custody of such persons in the police. So, the magistrate is under obligations to inquire as to who is being informed about the arrest of such persons, and whether the relatives or friend are willing to come forward or not, and whether the such kind of entry is being made in the police diary or not. So, and this is the court further said that this is the right which has been ensured by the clause 1 and 2 of the clause 1 and 2 of article 22 of the constitution, and this rights must be strictly complied with by the police officers. And it is not something end of the rights, it is something in addition to the right which is being provided to such person who is arrested by the police. along with, apart from the right which has been provided by the jail manuals or the instruction which has been issued by the Director General of Police. So, first thing is that you have the right to be informed of the ground of arrest. Now, I am coming to the second requirement, that second right which is being provided by clause 1 and 2, that is the right to consult and to be defended by the legal practitioners of his choice. Here the clause 1 of article 22 further stipulates that person arrested shall not be denied the right to consult and to be defended by the legal practitioners of his choice. So, basic objective of this right is that if you are having the right to consult and right to be defended by the legal practitioner of your choice, then it will enable the detainee to prepare his defense, and this right belongs to arrested person not only at the pre-trial stage, but this right can also be enjoyed by the arrested person at during the trial before the court or before the special tribunals. Even this right can also be claimed when he is further pursuing the matter by way of appeal. Earlier, in some of the cases, the Supreme Court has taken the view that the right to consult the lawyer cannot be accorded to the arrested persons unless he has made a specific demand. But I have already explained you the Menka judgment under article 21 of the constitutions. After Menka judgment, now it is being imperative for the state to provide the service of the lawyers to the such detained persons if he is not having capacity to engage his own lawyers. I have already explained to you Husainara Khatun case also. In the Husainara Khatun case, Supreme Court has emphatically stated that it is the constitutional right of the every accused persons who is unable to engage a lawyers and secure a legal service on account of the poverty, indigence, incommunicado or any other reasons to have the free legal service at the cost of the state. And it is not something which can be considered a charity of the state. It is the right which directly flow from article 21 of the constitutions as well as article 22 of the constitutions. So, if the person is not in positions to engage his own lawyer, then that case lawyer will be provided by the state at free of cost. And for this purpose, we already have the National Legal Service Authority Act, and the National Legal Service Authority Act as well as the State Legal Service Authority Act mandate the state to enroll the such lawyers who are willing to provide the legal assistance to the person who is being arrested or detained by the police under the ordinary law. Then I am coming to the third requirement, the third right which is being provided by article 22 of the constitution, that is the right to produce before the nearest magistrate. If you see the provisions of clause 2 of article 22 of the constitution, it says that every person who is arrested or detained in custody shall be produced before the nearest magistrate within the period of 24 hours of such arrest, excluding the time necessary for journey from place of the arrest to the court, place of arrest to the court of the magistrate. So, the basic objective of that the such person who is being arrested by the police must be produced before the nearest possible magistrate within 24 hours is just to avoid any miscarriage of justice on the part of the police authority, and it is something also intended to correct and approve the executive actions of arresting a person. Because if any person be arrested, it is not merely that his liberty to move is being curtailed. Here the most cherishable rights which is being provided by article 21, that is the right to life and personal liberty which are at stake. So, that is why if the police effected arrest, then they must seek the judicial approval, and judiciary is supposed to apply its judicial mind to determine whether the arrest was regular or legal and it is in accordance with the law. And for this purpose, the judiciary is required to scrutinize the circumstances, and if he is satisfied that this requirement is being fulfilled, then that case they can decide as to whether such person is to be put under the police custody or such person must be sent to the judicial custody. The other important thing which you have to keep in mind with respect to the interpretation of word nearest magistrate, because if the word which has been used under clause 2 is that he must be produced before the nearest magistrate within 24 hours. Now, the question will arise to whether the nearest magistrate will be considered the magistrate who is having jurisdictions to decide about the such cases, or the magistrate which can be found nearest to the place of arrest. With respect to this, the court has clarified that the nearest magistrate under Article 22 clause 2, Article 22 clause 2 refers to magistrate acting under judicial capacity under the section 167 of the CRPC. It means if the person is arrested by the police under the section 64 of the CRPC in exercise of executive power, then such persons must be produced before the nearest magistrate who is exercising power under section 167 of the CRPC. So, nearest magistrate simply means the magistrate found to be the nearest to the place of arrest, and it is altogether immaterial that whether the magistrate has or does not have jurisdictions to try the case, or the magistrate sit in a court or not at the time of the arrested persons is produced before him. And it is being strongly urged by the Supreme Court that the state and the police authority must ensure that this constitutional and legal requirement to produce arrested persons before judicial magistrate within 24 hours of arrest must be strictly observed. If the person who is arrested and after the arrest, if that person is not being produced before the nearest magistrate within 24 hours of arrest, then that case it itself will be sufficient to make such arrest illegal and the person is liable to be released on bail. And with respect to this, the Supreme Court also has the occasions to clarify the scope of this right in the CBI versus Anupam J. Kulkarni case in year 1992, where the Supreme Court has laid down the detailed guidelines which will govern the arrest of the accused persons when investigations cannot be completed within 24 hours. What the Supreme Court in Anupam J. Kulkarni case has said that when the person is arrested under section 57 of the CRPC, then he should be produced before the nearest magistrate within 24 hours. Second, the judicial magistrate can authorize the detentions of the accused in such custody, whether it may be a police custody or judicial custody from time to time, but the total period of detentions cannot exceed 15 days in a whole. So, it means police will have the power to detain such persons or take the custody of such persons for the 15 days at best. Here this 15 days may be in one stretch or 15 days may be in the 2 or more stretch. So, what the practice which is ordinarily followed by the police is that the police generally takes such persons to custody for the 4, 5, 6, 7 days just to carry out the preliminary investigations, and after carrying out the preliminary investigations, after eliciting the certain kind of information from the accused persons, they will carry out the further investigations, and if appears to the police that the further remand is necessary, then they can apply to the magistrate, and magistrate can accordingly subject such persons to the police remand or police custody. But the total period of remands cannot exceed 15 days at a whole. So, after the expiry of the 15 days, further remand can only be in the judicial custody. There cannot be any detention in the police custody after the expiry of first 15 days. And it is not only that the police will have the power to carry out the initial investigation within this period of 15 days. Here the police is also required to file the charge sheet. So, if the investigation is not completed within 90 days or 16 days as the case may be, then accused is entitled to release on bail under section 167 clause 2 of the CRPC. So, this period of 90 days and 60 days concerns, it has to be computed from the date of detentions as per the order of magistrate and not from the date of arrest which was being made by the police. So, what is happening today is that most of the cases the police are not able to complete the investigation within 60 days or 90 days as required in the provision of CRPC, and the delay on the part of the police itself accord the right to the persons to demand that he should be released on bail. So, here this is the mandatory requirement, and it is somehow that the police, because the lack of alertness or because of the complexity of the case, in most of the cases they are not able to complete the investigations within the stipulated period as provided under the CRPC. As far as the Anupam J. Kulkarni case is concerned, this is a very welcome ruling on the part of the Supreme Court, because if this ruling is being strictly followed, then it would save many of the under-trial prisoners who from the police atrocities, as they cannot be kept for the unduly long period under the police custody, and same time it will also mandate the police officers to make their all out efforts to ensure the completion of investigations within the stipulated period as provided in the CRPC. The fourth right which is provided the right not to be detained custody beyond 24 hours without the authority of the magistrate. So, they are the four specific right which is being provided by the clause 1 and 2 of article 22 of the constitutions, and it has to be strictly followed. Then apart from the clause 1 and 2, you have the clause 3 of the article 22, which is being recognized as one of the exceptions to the clause 1 and 2 of article 22 of the constitution. It says that any person who the clause 3 of article 22 provides that the safeguard granted by clause 1 and 2 of article 22 are not available to the following persons. First, any person who for time being is an enemy aliens, and second, any person who is arrested or detained under any law providing for preventive detentions. So, only with respect to the enemy aliens or any person who is being arrested under the preventive detentions law, this provisions of clause 1 and 2 of article 22 shall not be applicable. Now, I am coming to the second aspect of article 22 of the constitutions. It provides for the preventive detentions law. Now, first questions which will arise with respect to that, what is meaning of preventive detentions law, what is the objective of the preventive detentions law, and what is the justifications for providing this kind of provisions under Indian constitutions, because you cannot find the same or similar kind of provisions in any other constitution of the world, but this is something which is a unique provision which is being included under the Indian constitutional provision. As far as the term preventive detention is concerned, it simply say the detentions of the persons without trial in such circumstances that evidence in possession of the authority is not sufficient to make a legal charge or to secure the convictions of detainee by the legal proof, but sufficient to justify his detentions. So, here the term preventive detentions is being used in contradictions to the term punitive detentions. Under the punitive detentions, a person is being arrested for the whatever the criminal wrong which he has already committed, but under preventive detentions law, person is not being detained for the wrong which he has committed, but the wrong which he intends to commit. So, here this is the provision which empowered the police to intercept the such persons and to prevent or take such person to custody before he go and commit any offence. So, the basic object of preventive detention law is not to punish, but to intercept, to prevent the detainee from doing something prejudicial to the state or to prevent them from committing any crime. And the sole justifications for enactment of this provision is that the suspicions or reasonable apprehensions or reasonable probability of the impending commissions of the act, which can be safely classified as something which is prejudicial to the maintenance of the security state, maintenance of the public order, maintenance of supply of essential commodities. So, the basic objective or basic justifications of providing the preventive detention law is to prevent the abuse of freedom by anti-social and subversive element. When this issue was being taken by the Constituent Assembly, then the Constituent Assembly member was quite furiated. They did not wanted that they were contending that you are one hand you are providing the citizens right to life and personal liberty, and the personal liberty you are claiming or cherishing as the most sacrosanct provisions of Indian constitutions, and other hand you are also incorporating the provisions where the persons can be detained merely on the basis of apprehension that if he is not being taken to custody, then he is going to commit the offence. But when this issue was, when the members of the Constituent Assembly was infuriated, then at that point of time Dr. Ambedkar intervened. What he contended before the Constituent Assembly, that the liberty of the individuals or liberty of the citizens or liberty of any other persons cannot be bigger than the security cannot be bigger than the security of the nations. So, this is just to ensuring the security of the nations, we have intended to provide the preventive detention law. But the reasoning which was given by the Ambedkar, it was not sufficient to just to calm down the members of the Constituent Assembly. Then during the Constituent Assembly debate, he again produced the other argument, and what he contended that this is the minimum procedural safeguard which has been provided just to, because if anybody wanted to achieve their objective, and for achieving their objective, if they are following the constitutional means, if they are following the constitutional methods, then the questions of invocations of preventive detentions law will not arise at all. It is only in those cases where the persons, because of his over ambitions, if they wanted to achieve their constitutional objective, and if they wanted to achieve their objective and or to pursue their goals, and the purpose of pursuing their goals, if they are adopting the unconstitutional means, if they are indulging in subversive activity, then only in such cases the questions of invocations of preventive detentions law will arise. So, somehow it was able to justify it was able to pacify the members of the Constituent Assembly, and finally the draft article of 15A is being given the new articles under Article 22 of the Constitution, which deals with the preventive detention law. And it is not only the constitutional debate, here the rationales of the inclusion of this provision was also being considered by the Supreme Court in A.K. Gopalan versus State of Madras case way back in year 1950, where Justice Patanjali Shastri, speaking on behalf of the court, has said that this sinister looking feature so strangely out of the place in a democratic constitutions, which invests the personal liberty with the sacrosanctity of the fundamental right, and so incompatible with the promise of the preamble, is doubtless designed to prevent the abuse of freedom by anti-social and subversive element which might imperil the nation's welfare of the infant republic. So, it is only because of their apprehensions that if this kind of provisions will not be incorporated in the Indian constitutions, then these provisions might be abused by the subversive element, and they will try their best to somehow put on a stake the very safety and security as well as the territorial integrity of the nation itself. That is why they have decided to incorporate the preventive detention law. The next questions with respect to preventive detention law is arise to who will have the power to make such a preventive detention law. If you see the scheme of the 7th schedule of the Constitution, if you see the entry 3 of the list 1 of the 7 schedules, which empowered the Union Parliament to make a preventive detention law. It says that the Union Parliament will have the power to make a preventive detention law for the regions connected with the security of a state, maintenance of the public order, or maintenance of supply and services essentials to the community, and the person subjected to such detention. So, under entry 3 of the list 1 of the 7 schedules, Union Parliament will have the power to make a preventive detention law. Apart from entry 3, you also have the provisions that is the entry 9 of the list 1, under which the Union Parliament will have the power to make a preventive detention law, and entry 3 of the list 3 of the state list, where the state government will have, state legislature will have the power to enact a preventive detention law. So, the only thing which has to keep in mind with respect to preventive detention law which was enacted by the Union Parliament is that it must be connected with the defence, foreign affairs, security of India, and only for these reasons they can enact the preventive detention law. As far the competency of state legislature is concerned, the state legislature's power is more broader, and the state legislatures can enact a preventive detention law for the purpose of security of state, maintenance of public order, and maintenance of supply and services essentials to the community. So, Essential Community Act is also one of the grounds under which the state will be empowered to go for the preventive detentions. Now, I am coming to the history of the preventive detentions law. When the constitutions came into force, then immediately they have realized that for the putting a proper check on the subversive element, we need to have the preventive detention law. And the first preventive detention law was enacted by the Parliament in the which was named as the Preventive Detention Act of 1950. It was enacted on 26 February 1950. It was purely a temporary measures, and it was supposed to cease to have the effect from the 1st April 1951. But somehow the durations of this act was being extended, and it lasted till 21st December 1969, when it was allowed to lapse. And after the lapse of the Preventive Detention Act of 1950, the Parliament has immediately enacted the other preventive detentions law, and that preventive detention law is popularly known as Maintenance of Internal Security Act 1971, which is popularly known as MISA Act. And this MISA Act, which was enacted by the Congress government, it was finally deleted by the Janata government when they came into power on 3rd August 1978. Then after the lapse of the MISA, the immediately government has again realized the importance that we needs to have the other preventive detention law. So instead of the enacting the preventive detention law specifically, or the maintenance of internal security, something a substitute of the MISA or the Maintenance of Internal Security Act, they have decided to enact a other preventive detention law within the 2 years of the lapse of the MISA. And the new act was being named as Preventions of the Black Marketing and Maintenance of Supply of Essential Commodity Act 1980. And if you see the salient provisions of the Black Marketing and Maintenance of Supply of Essential Commodity Act, it said that it required the detaining authority to furnish the ground of detentions within 5 days from the date of detentions, and which can be extendable for the 10 days in exceptional circumstances, and within 3 weeks the government is required to submit a report to the advisory board, which in turns required to submit their report to the government within 7 weeks. And under the Preventions of the Black Marketing and Maintenance of Supply of Essential Commodity Act 1980, a person could be detained maximum for a 6 month under this act. And the act which was enacted in 1980, it is still in force. And after apart from the Preventions of Black Marketing and Maintenance of Essential Commodity Act, the other preventive detention law was being enacted by the Parliament in the form of ordinance that is known as the National Security Ordinance of 1980. And this National Security Ordinance is being replaced by the National Security Act of 1980, and this law is still in force. And if you see the provisions of the salient provisions of National Security Act of 1980, here this act was being enacted by the Parliament with the sole objective of detaining a persons who are responsible for the communal and caste right and other activities which can be classified as something which is prejudicial for the maintenance of peace in the country. And this National Security Act, it provides for detentions up to a maximum period of 12 months, but it does not debar the detainee from challenging his detentions in a court on the ground that, among other things, it is also amounts to infringement of his fundamental right. As far as the rights of the detainee under the National Security Act is concerned, the detainee will be conveyed the ground of detentions within 10 days of his detentions, and he also had the right to be represented before the advisory board against his detentions. And this act was extensively amended in year 1984 just to plug the certain loopholes which was seen in the working of this act. And as far as the constitutionality of the National Security Act 1980 is concerned, here the constitutionality was being challenged before the Supreme Court in one of the famous case, that is the A.K. Roy versus Union of India in year 1982, where the Supreme Court by majority of 4:1 upheld the constitutional validity of National Security Ordinance as well as the National Security Act by saying that the act is neither vague nor arbitrary in its provisions, providing for detention of persons on the certain grounds as acting in any manner which can be classified as prejudicial to defense of India, security of India, security state, and to India's relations with the foreign nations. However, the court has issued a certain guidelines, certain safeguards which has to be followed by the police authority if any person is being detained under the preventive detention law. And if you see the safeguards which is being provided by the Supreme Court in A.K. Roy case, is that if any person is being detained under the National Security Act, then immediately after his detentions, his kith and kin must be informed in writing about his detentions as well as his place of detention. So, if the person is being taken to custody, then his relative must be informed that he is being taken to preventive detention law and it is the place where he has been kept. Apart from this, the detainee must be detained a place where he habitually resides, unless the exceptional circumstances require detentions and some other place. Because here the under preventive detention law, you are not detaining the persons for something wrong which he has committed, but you are detaining the person merely on the basis of apprehension that if the person is being not detained, if the person is not being taken to custody, then there is every possibility that he may inflame the communal or the caste, he may just somehow instigate the communal and the caste rights. So, that is why here if he is been taken to custody, then he has to place, he is to put in the place where he habitually resides. Apart from this, the person's detainee is also entitled to his book and writing materials as well as his own food and visits from his friends as well as relative. So, you see how the Supreme Court has gradually tried to circumvent the scope of National Security Act, and whatever the teeth which is being provided in the national security is somehow being tried to be diluted by the judiciary. At the same time, judiciary has also tried their best to somehow empower the citizens. They have tried their best to somehow the safeguards or right which is being provided citizen must be strictly observed, must be scrupulously followed. Apart from this, it is not only that he is entitled to book, food or the visit by his friend relatives, he is also entitled that he is to be kept separate from the convicted persons. Suppose he is also required to be put under the jail premises, then definitely the care has to be taken that he is not in the he is not living along with the other convicted persons. And apart from this, no treatment of punitive character should be meted out to him, and he should be treated according to the civilized norms of the human dignity. So, A.K. Roy is a very significant finding on the part of the Supreme Court, where the Supreme Court has tried to enrich the rights which is accorded to citizens by the Part 3 of the Indian Constitution. However, at the same time, if you see the minority views, here the minority view has severely criticized the approach of the government, because the preventive detention law, the teeth of the preventive detention law is somehow being tried to be diluted by the Parliament by enacting the Constitutional 44th Amendment Act. And by the Constitution's 44th Amendment Act, it is being provided that if any person is being detained under preventive detention law, then his case has to be referred to the advisory board before the expiry of the period 3 months. But what is being provided by the 44th Amendment is that if any person detained, then his case has to be referred to advisory board before the expiry of the period of 2 months. But it is the most unfortunate thing of this country that the Parliament has decided to introduce amendment. That amendment is being passed by the Parliament, it has become act, but the 44th Amendment Act also contains a provision that when this amended provision has to be brought into force, and here the central government is being given power to bring the 44th Amendment into force. But you will be surprised to know that way back in year 1978, Parliament has amended the constitutions, Parliament has introduced the change, but that change is not yet being notified. So, you still have to rely upon the provisions which was in existence before enactment of 44th Amendment Act, and whatever the safeguard or whatever the softness which is being introduced by the 44th amendment, it cannot be demanded by the any persons. And if you see the approach of the some of the judges of the Supreme Court in the A.K. Roy case, particularly Justice Gupta and Justice Tulja Purkar, where he has decided to issue a mandamus to the government to bring the amendment into force. But here the government is not bound by the such the mandamus. Mandamus is the kind of writ which is being issued by the judiciary to the executives to perform their mandatory obligations or the imperative obligation which is being imposed by the any specific act. But still the central government has not decided to bring the 44th Amendment Act into force. Apart from the National Security Act, in 1987, the Terrorist and Disruptive Activity Act, that is popularly known as TADA, was being enacted, and this TADA was being enacted just to deal with the specific kind of the terrorism which was prevalent at that point of time in the state of Punjab, Kashmir and some of the northeastern state. But later on the TADA was allowed to lapse and it was being replaced by the other provision that is known as the POTA. That is the Prevention of the Terrorism Act, and the POTA is also being allowed to lapse. Now I am coming to the other provisions, the other safeguards, the constitutional safeguard which is provided to the persons who is being detained under the preventive detention law under the clause 4 to clause 7 of Article 22. If you see the provisions of the clause 4 to 7 of Article 22, it guarantees the three kinds of the right to the persons who is being arrested under preventive detention law. The first right which is being accorded by the clause 4 to 7, that if any person be detained under preventive detention law, then his case has to be reviewed by the advisory board. And the second right which is accorded to such person, that he must be communicated of the ground of detentions, and third, the such detainee will have the right to representations. Here this right to representations can be exercised by the such detained persons either before the advisory board, or they can also exercise the right to representation before the appropriate government, and appropriate government is under constitutional obligations to expeditiously decide about the representations which was being made by the such detained persons. Now I am coming to the first aspect, that is the clause 4 to Article 22, and I am taking up the provisions which was in existence prior to the 44th Amendment Act in 1978. What the clause 4 provide, that the no law providing for preventive detentions shall authorize the detention of persons for a longer period of 3 months unless a advisory board constituted of the persons who are or have been or qualified to be judge of the High Court has reported before the expiry of the said period of 3 months that there is in its opinion sufficient cause for such detentions. So it means if any person is being detained under preventive detention law, then that case his case has to be referred to the advisory board before the expiry of the period of 3 months from date of such detentions. Here the advisory board has been if you see the functions of advisory board, here the advisory board is only required to examine the existence of the sufficiency of the reasons. If the advisory board considered that there was sufficient justifications or sufficient reasons for effecting such arrest, then accordingly the advisory board will communicate to the government, and government will decide about the durations or period to which such person has to be detained. So the advisory board merely examine the sufficiency of the reasons, and so the basic objective is that if any kind of the misuse is being committed, any kind of the misuse or misapprehension is being entertained by the authority before arresting the persons, then advisory board will advise accordingly. As far the constitutional advisory board is concerned, earlier the person who is required to be member of the advisory board, the only requirement was that he is qualified to be judge of the High Court, who are or have been qualified to be judge of the High Court, and they are required to submit a report before the expiry of 3 months. But by the Constitution's 44th Amendment Act, this provision is being amended, and now what is being provided that if the advisory board had to be constituted, then it has to be constituted in accordance with the recommendations of the Chief Justice of the appropriate High Court. And second, the composition of advisory board is also being changed. Now what is being proposed by the Constitution's 44th Amendment Act is that the board shall consist of one chairman and not less than 2 other members. As far the qualification of chairman is concerned, what is being prescribed that chairman shall be the serving judge of the appropriate High Court, and other member shall be either a serving or retired judge of the High Court. So the basic objective of the 44th Amendment was that the advisory board should be independent and impartial body, and it must be free from executives. But the changes which is being introduced by the Constitution 44th Amendment Act, it is not yet brought into force. Now the constitution of advisory board at present time is entirely at the prerogative of the executives, and executives, if they wish, they can have their own persons or the persons of their choice as a members of advisory board, and sometimes it is being apprehended by the citizens or the persons who detain that advisory board is not examining the case on the basis of the available materials, but they are being influenced by some other considerations. As far the procedures before the advisory board is concerned, here the advisory board is only required to inquire about the sufficiency of the reasons. So once the case, if the person is being arrested and his case is being referred to the advisory board, then the questions will arise to what kind of rights which he have before the advisory board. As far the right to detain before the advisory board is concerned, here the first or the most important requirement of the clause 4 to 7 is that the detainee must be communicated of the grounds of detentions. So clause 5 of article 22 impose an obligation on the government to communicate the ground of detentions, and for this requirement, if the ground has to be communicated, then it must be very clear and easily understandable. So there must be a rational connections between the grounds stated by the government and object for which the person is being taken to the preventive detention law. Here, if you see the preventive detention law, the basic objective of the preventive detention law is just to prevent the persons who is carrying out any activity which can be characterized as something which is detrimental to the maintenance of the security state, or which is something which is detrimental to maintenance of public order. So here the court has also made a distinction between the maintenance of public order and as well as the maintenance of or infractions of mere law and order. So what when I was discussing article 19 of the Constitution, at that point of time I have explained you that how the court has distinguished between the law and order, public order as well as the security state, and the law and order is something which you can say the bigger circle where the every infractions of law is not necessarily something which is going to affect the public order, but public order is something more than that. So as far as the ground is concerned, the ground must be very clear, specific, and should not be vague, irrelevant or non-existence in nature. And the other thing is that how the ground has to be communicated, because here the Constitution is silent with respect to that. Here the judiciary has provided some kind of the scope that if the ground which has to be communicated, it has to be communicated in a language which he can easily understand. Suppose if the person is not having the sufficient working knowledge of English, and if the ground of arrest is being communicated to him in English, then definitely in that case he will not be in positions to appreciate as what are the ground on which he is being arrested. Mere apprehensions, mere contention of the police that since he has put his signatures in writing does not mean that he is having the working knowledge. Suppose if the person belongs to a particular state and where he is very much affluent with the regional language, then that case it is imperative on the police officers to ensure that the ground of arrest must be communicated to him in a language which he can understand at best. Apart from this, it is not merely that the ground of arrest has to be communicated to him. Here it has to be placed before him in writing. So once he know that what are the grounds, what are the basis on which he is being detained by the police under preventive detention law, then that case he will be in positions to prepare his ground, prepare his defense, and he can give the effective representations either before the government or before the advisory board. I think we are running short of the time.
So we have covered today preventive detention only.
Just two aspects we are not able to cover.
Okay,
The
can you briefly talk about?
I think
Will take time.
it will take time, because otherwise they will not able to comprehend that what
Okay,
kind of the
so
right they are having when they are making representation before the government, and whether representation has to made before which government, whether it is to president or governor or it is to appropriate ministry or the official concerns, because you have the.
Okay, so we will have explanation of these aspects in some other some in other lecture, friends.
Some other articles.
So well, friends, we have been able to explain briefly, you can say, the some part of the preventive detention provisions that is in the Article 21 of the 22 of the Constitutions. So I hope you have got understood all these things. So and with hope we'll organize some other lecture on this very topic some other day. So with this we conclude today's lecture. I thank all of you for watching the lecture, and on behalf I thank Dr. Rakesh Kumar for giving such a wonderful lecture on this very topic. Thank you very much.